Mr. Chu.
Thank you, Mr. Chair. I'm a co-author of this bill, and I want to take a few moments to talk about what I have seen, certainly as someone who represents a city that has had a similar policy in place. When we had a discussion at our Board of Supervisors on this, we heard a lot of the same arguments that were being brought up today. And the fact of the matter is, as I think one of the witnesses pointed out, not only in San Francisco have we seen thousands of workers that have been able to successfully work through this with management, and not only have we seen quite a few grocery store transactions, but this has actually been good for business in a number of ways. And I actually want to take a moment and thank the local business community in my town that when we had a similar discussion around retention policies a number of years later, decided not to oppose it, but actually went neutral because we really didn't see the parade of oppositional issues that we had thought were going to arise. I want to take a moment and just to mention a few things to respond to our colleagues' questions around the damage that we have seen. We know that when you don't provide any certainty to workers, it is not only enormously disruptive, but many of these workers, because they do not think they will have a job, are forced to start to look for other options. In fact, we had many workers who literally left our city because they didn't think they were going to be hired by a new employer. They didn't know how to reach out to that employer. And in fact, I'd encourage a number of employers to set up early job interview sites, and that just didn't happen. And so the lack of continuity really ruptured our community and our community fabric. And the flip side of it, once you have a 90-day window, what we have seen is workers will do whatever they need to. They'll work incredibly hard to prove themselves during that time period so that they will be retained. And I certainly think that has turned out to be a very good thing for those businesses that have a workforce that has already learned how to work together, know what their operations have been, and can really move things forward. So from my perspective, I think this is something that has worked. And let me just close with one point. Unlike other industries, every community, every neighborhood needs a grocery store. And so the idea that somehow this is going to diminish transactions, I think quite the opposite. I think it'll really smooth out those transitions in ways that are positive. And so with that, again, happy to co-author and also happy to make a motion to move this forward.
Thank you. The motion is to pass as amended. There's a motion. Is there a second? We do have a second. Thank you. All right. That ends our... Mr. Chow.
Thank you, Mr. Chairman. I'll be supporting the bill today. However, I do have some concerns still, two of which actually we talked about last night, and I will reserve my right to change my vote next time I vote on it. But I do encourage you to continue working with the opposition. Thank you very much.
Mr. Wagner?
Thank you. I wasn't going to weigh in on this. I thought Mr. Gallagher did a nice job, but I guess I need to ask the author, excuse me, whether she agrees with the assessment we just heard from our colleague from San Francisco that this 90-day window will provide an incentive for these workers to really prove themselves, work hard, make sure they get to keep the job. I mean, that's part of what's going on here, isn't it?
Well, part of it is, yes. That
okay.
Well, I think they're not going to work any harder than they work. I mean, I happen to think grocery workers are extremely hardworking. They're very good at what they do. We've seen time and time again during strikes and whatnot that they're some of the most successful because we have such good relationships with our grocery workers. So I don't want to say that they're going to work harder, but are they going to do their job? Absolutely. And does it prove possibly to an employer that, hey, this is a benefit to us? Yes. Okay, so they're not necessarily going to work harder during this period of time. Who knows? I think they're going to work hard. Again, and thank you. I want to thank you because I think we're getting at the same thing.
We clearly are.
It's clearly that there are misconceptions about what a union contract and what a worker working under a union contract does. So this idea that somehow union workers are lazy or they don't work as hard and that they're all of a sudden their job's in line and they're going to have to work harder, I don't think is accurate. It's not been my experience. So,
I didn't say that. My friend from San Francisco said that.
But no, he didn't. He just said that they were going to work very hard. But I think that this is the sad thing, and we saw this at the airport as well when we had worker retention. There is a fear out there, especially in newcomers to the market, these folks who start as mom and pops. There's this fear about unionized workers somehow. There's all these presumptions that have been placed out there, unfortunately, in our media, with no backing. I mean, this is ridiculous. So they are fearful that they're going to have, a lazy workforce or an entitled workforce. And I think it gives them an opportunity to see, even in those situations, this applies to union and non-union grocery stores alike. But in those times, it allows them to see what workers can do for themselves and make a decision about whether or not to retain them.
Well, I think it applies to union workers and non-union workers as well. I think it applies to human nature. And I think my friend from San Francisco is exactly right that will be the upshot of your bill. Will make folks work even harder to retain their jobs. I'm not saying that's a bad thing. I am saying, however, that it is, I think, a reason why we ought not only retain at-will employment in this state, but ought to really make it mean something. And I think, unfortunately, your bill, for the reasons Mr. Gallagher explained, goes in the wrong direction. In fact, I think, as you just tried to explain, kind of backing away from that concept. Just so long as you and I both know, I think we did just get to the nub of this, and I appreciate your honesty, at least in recognizing that, and that's why I'm not going to support your bill today.
Can I respond to that?
Sure.
I just want to be clear that if a worker is not doing their job, that is cause to remove a worker. And in no way does that change for that 90-day period or any time after that. So at will, let's be clear what at will and cause mean. And so if we said at will is a way to ensure that workers work hard and do their job, as we've continued to take away the rights of workers in the workplace, productivity continues to go up. That it doesn't matter. You have the ability at any point to reduce your workforce for cause if a worker is not doing their job.
But don't
even in the 90-day period here.
But don't you agree that there is a difference between somebody who's doing their job and somebody who's busting their butt to do their job? And it ought be the ability of the employer to draw those distinctions and not have to come up with cause, because as do I've done employment litigation, you've done employment litigation. Cause is a somewhat higher standard in the law.
Absolutely.
All right. So just say, well, for cause doesn't really get to the nub of the problem, and that is the right of the employer to actually have an at-will employee workforce, and the right of the employer to draw distinctions between their employees. I mean,
but this is for 90 days. As soon as that 90-day period is over, that employee, even if they were busting their butt, and so the employer says, I'm going to retain this worker, they were busting their butt and they're a hustler, at 92 days, if he slacks off, he can still be let go at will. So it's a temporary situation.
It's a temporary.
I'm not introducing a bill to get rid of at-will employment in California this time.
No, I'm
No, actually, that was a joke. I have no intention to introduce that bill in California this year.
We'll see. The joke's going to be on California because that bill's coming. I know it. Thank you, Ms. Gonzalez.
Mr. Gallagher, something else you need to know?
Just something that got brought up. It reminded me. I think there is concern that this might impede transactions from going forward. Like there was some testimony about an organization that wants to do 25 stores, but they didn't go into Los Angeles County because of this ordinance. And as we know, we have areas in this state that are food deserts where there aren't grocery stores, right? And people don't have access. And my colleague kind of brought up that could be an issue. Mm-hmm. And aren't we sort of tacitly admitting that this does cause problems by exempting this requirement in areas where there's a food desert?
No, that's a different situation. So a food desert is one where there has been no store, right? So we're exempting those locations even if a store has then opened up into a food desert, right? Because of a variety of reasons of why stores don't open up in food deserts. And I forgot your initial question where you started to ask.
Well,
The 25 stores. The purchaser of, or whoever wants to open 25 stores in California, I've asked the Grocers Association. I'd love to know who that is. I have some suspicions of who that is, and I'm, it's unfortunate if a store does not want to open up in an area because they have to retain a workforce, and they might have to be recognize at some point a union if those workers decide to stay in a union. I can imagine. I'd love them to disclose it, but they won't. So we're talking about speculative kind of process now. There is this employer who will not open up. Are you going to tell me they're not going to open up in all of California because this exists? I highly doubt that. Yeah.
I'm just saying that there could be an impediment to that. And in the cases of food deserts, we want stores to move in. And a food desert could be an area where there's just one grocery store.
Sure. And they'd be exempted in this bill.
You want to keep that. Exactly. But why are you exempting it? Because you fear that it might cause an impediment to somebody coming in and taking over that store.
We don't want any excuses in food deserts.
She's trying to get your vote. Mr. Chu.
I'm going to be very brief. I know we have a lot of colleagues with bills continue, but I do want to respond to the suggestion from our good colleague from Orange County. What I was suggesting, there are some opponents who are saying that during this 90-day period, these workers are actually not going to work that hard because of the protection they have. And I want to be very clear that I think they will work just as hard as they had been when they were in the situation before that 90-day period, because for reasons that we've already discussed. So just want to clarify that in case there was any confusion.
All right, thank you, members. Ms. Gonzalez, I appreciate this bill. To me, this bill is about stability in a community when a new company comes in to take it over. And notwithstanding I think, a stretch of logic to apply the circumstance to the legislature here, although it does remind me that some of us need to work a little bit harder every 2 years for a brief period in order to retain our jobs as appropriate. The analogy doesn't quite settle, especially when you're looking at the impact in a community when a major employer and a significant part of that community is transitioning. So with that, you may close, Ms. Gonzalez.
This really is about maintaining the backbone of the middle class in communities like mine, where unfortunately there are so few jobs that provide a middle class lifestyle. There is no need to continue to reduce the wages of grocery store workers. But we do it because now Wall Street has had a big play in private equity firms in the way we do the grocery business. So I understand we may come from different places, but this is about protecting good jobs in so many of our communities. I respectfully ask for an aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo?
Aye.
Alejo, aye. Chow?
Aye.
Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
No.
Gallagher, no. Garcia?
Aye.
Garcia, aye. Holden? Holden, aye. Mainshine? Mainshine, no. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out. Thank you. That brings us to item number 4, AB 1028. Mr. Bonta. Morning.
Morning, Mr. Chair, colleagues. Today I'm pleased to present AB 1028. I would like to thank the Chair and committee staff for their hard work on amendments to the bill with my staff and stakeholders. Thank you. These amendments have removed all opposition to the bill and have made the bill a stronger one. Appreciate your assistance and collaborative work. AB 1028 cures an injustice in current law. Existing law authorizes retired judges in the state of California to administer oaths and affirmations. However, the law precludes judges retired on disability from enjoying the same right. Administering oaths or affirmations does not require a feat of physical power or agility. The fact that a judge or justice may be retired for disability because he or she could not perform all of the duties of a judge or justice all of the time is inconsequential to the individual's ability to perform the ministerial task of administering oaths and affirmations. AB 1028 creates a pathway for disabled judges to administer oaths and affirmations, as well as provides the necessary public oversight of judges performing ministerial duties in California. The amended version of the bill establishes a medical certification process administered by the Commission on Judicial Performance. The process ensures that retired judges are fit to administer oaths or affirmations and standardizes the procedures regardless of the manner of retirement. With me today, I have a witness in support, Judge Richard Bartolini, retired from the Alameda County Superior Court.
Thank you. Mr. Bonta, you're taking the amendments as author's amendments?
Taking the amendments. Thank you.
Thank you, sir. Your witness, please.
I am Chester Richard Bartolini. Some time ago, I was retired on disability from my position as a judge of our Superior Court. Last year in December, I was asked by our newly elected mayor to administer her oath of office. Of course, I had to say no. In addition, our next-door neighbor, Noel Wise, was appointed a judge of the Superior Court in Alameda and pleaded with me to officiate at her induction. With much sadness, I again had to tell her I could not because of this legislation. Previously, my attention was drawn to Section 2093C of the Civil Code of Procedure, Chapter 3, Oaths Administration, which provides that, quote, a former judge or justice of a court of record of this state who retired or resigned from office, other than a judge or justice who was retired by the Supreme Court for disability, shall have the power to administer oaths and affirmations. Echoing Mr. Bonta, the same language appears in Government Code Section 1225. As he has pointed out, administering oath or affirmation does not require a feat of physical power or agility, and therefore the fact that I was retired on disability because I could not physically perform all of the duties of a judge all of the time is not relevant. For no good reason, it appears to punish a judge for a disability from performing a ministerial act. This bill does, in fact, eliminate that discrimination, and I urge a yes vote on the legislation.
Thank you. Any other witness in support? Seeing none, I do have a motion and a second. Are there any witnesses in opposition, any testimony in opposition to this bill? Seeing none, questions, comments from committee members? Seeing none, Mr. Bonta, you may close.
Thank you for your consideration today, Mr. Chair and colleagues. I respectfully ask for your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye.
And the motion is due pass as amended.
Wagner? Alejo? Alejo, aye. Chow? Chow, aye. Chu? Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Holden, aye. Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
Your bill is out.
Thank you, Mr. Chair and staff and colleagues.
Thank you.
And I will note that item number 8, members AGR 10, has been pulled at the request of the author, so we will not be hearing that. That now brings us to item number 6, AB 1408. Mr. Hadley. Good morning.
Mr. Chair, members, good morning. So I'm pleased this morning to present AB 1408. The current maximum fee of $10 per signature for most notarizations was set in 1993, 22 years ago, and has not been increased since. Notaries perform simple yet essential functions for our society. They verify the identity of the person signing a document. They confirm that the document is not signed under duress. They verify the signatory's basic awareness of the contents of the document, and sometimes they're required to take an oath from the signatory that the statements contained in the document are true. Every 4 years, notaries or their employers must pay approximately $350 to $450 to be certified, and this costs include everything from fingerprints to background checks to the cost of filing a bond. Under current law, notaries may only charge $10 for a signature, plus whatever mileage they travel under the standard mileage rate, which is currently 57.5 cents per mile. In parts of Los Angeles or the Bay Area, a 5-mile trip each way could easily mean an hour in the car, yet they're allowed to charge $5.75 for that travel. Allowing the market to set the price for most notary services will help ensure that the public has access to these essential services even when some travel or some inconvenience on the part of the notary is involved. More generally, these small business people should be free to set their own business terms, which is a right afforded to most other professional service providers. By removing this 22-year-old price cap and allowing competition to determine the terms of service, California will put notaries and their customers on a level playing field and ensure that these essential services are available when we need them. And finally, AB 1408 preserves current law stating that no fee will be charged to notarize voting materials, nor shall fees be charged to U.S. military veterans to notarize their veterans' benefits claims. This bill has received support from the National Notaries Association and has received no opposition that I'm aware of. And I respectfully ask for your aye vote, and we have some notaries with us today.
Thank you. Witnesses in support, please. You can come up to the table if you like. Or there, whichever. You can come up to the table if you like. Please. Good morning.
Push the button. My name is Amity DeYoung. I'm a notary public here in Sacramento County, and I support this bill.
Thank you.
Hello, my name is Joyce Marie Gonzalez, and I am a notary public in Tracy, California, and I support this bill.
Thank you.
My name is Elizabeth T. Hume. I am a notary in San Joaquin County, Manteca, California, and I do support this bill.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, I'll bring it back to the committee. And Mr. Hadley, as we discussed, I think I'd be happy to talk about the cap and maybe modernizing it, but for me to remove the cap just goes in the wrong direction. We're requiring people to get notarized signatures and with a lot of their daily lives and things that they need to do. And having the thought of having those rates escalate as they potentially could, I think is not the public policy that I'm willing to support, and that's why I'm recommending a no. Are there other questions or comments from committee members? Mr. Wagner?
Yeah, if I may, in an effort to maybe address and alleviate the chair's concerns, free market, don't we think there's a opportunity for the prices to go down with competition out there? I mean, we have some notaries here. Maybe they can suggest that that's as likely to happen, if maybe not more likely to happen.
I actually have thought about that, and yes, I did consider that, and it is something that I believe it would be whatever the market is paying, like real estate. If the competition in your area is high, then perhaps your fees would go lower, but I don't believe that they would go to an amount that the consumer would not be able to afford them.
Mr. Gallagher.
I guess just a question, what would make this industry different from any other industry that we have to cap it, at that fee? I'm still not sure I've heard why the notary industry would be different than, say attorneys. We don't cap our, fees, and a lot of times people need to utilize us for government functions.
That's correct.
No cap on us.
And there are plenty of opportunities for free and reduced legal services. In fact, that's one of the significant issues we will talk about is access to legal services in this committee, especially as we see the bar bill. Having been a notary and knowing that kinds of services that people require, to allow the market to take it out of potentially their range or a lot of people's ability to get notary services, I think is not the right policy. As I said, I was willing to work with the author and talk about potentially raising the cap or having a conversation about different services, but these are services that we require of people, that they need to go out and get notarized signatures. And I respectfully disagree with removing the cap.
So we'll work on a cap on attorney's fees together too.
You can bring that bill.
I want to bring it with you.
It's not relevant to the conversation right now, but we'll talk about that. I'm happy to, actually. Any other questions or comments? All right, seeing none, Mr. Hadley, you may close.
Just to speak to the cap for a moment, and to use one standard of comparison that may be relevant here. In 1993, when the cap was set, the minimum wage was $4.25 an hour. Effective January 1st of 2016, the minimum wage will be $10 in the state of California. So if we are going to set caps on these services, I think that a cap in the realm of $20 is consistent with what we as state lawmakers have done with the minimum wage in the last 22 years. More generally, to address the chairman's point and some of the questions that have been raised, the government of the state of California does set prices, cap prices, regulate prices in a number of contexts. But with respect, I struggle to understand the basis by which the state is capping the price for most notary services. There are very limited barriers to entry. There is no power inequity between the vendor and the customer. There are certainly no excess profits in the business. I suspect that most notaries are offering their service as a loss leader in conjunction with other businesses they may offer. It is very hard to make a living as a notary in the state. Even if the cap could be justified in theory, in practice, we as a legislature have been derelict in our duties. If we have let this cap sit at the same price for 22 years while our offices are filled with more powerful interest groups who come to the Capitol to lobby for rises in reimbursement rates and prices for their goods and services every year. So I'm proud to stand on the side of the small business men and women who provide these essential services, and I'm proud to stand on the side of the customers who need to make sure that they have access to these services even when travel or inconvenience is involved. In the case for people who cannot travel, who cannot drive themselves and need notary services. So I respectfully ask for your aye vote.
Thank you. And Mr. Hadley, based on your close, what your bill does is removes the cap.
Correct.
And to be clear, told you I was happy to talk to you about the cap.
Correct. No, this bill does remove the cap under most circumstances. That's right.
Correct. Thank you. All right. Call the roll. Oh, we don't have a motion. There's a motion. Is there a second? Second. There's a motion, and there is a second. Call the roll, please.
Stone?
No.
Stone, no. Wagner?
Aye.
Wagner, aye. Alejo?
No.
Alejo, no. Chow? Chu? Chu, no. Gallagher?
Aye.
Gallagher, aye. Garcia? No. Garcia, no. Holden? No. Holden, no. Mainshine? Mainshine, aye. O'Donnell? No. O'Donnell, no.
The bill fails.
Okay, I respectfully request reconsideration.
Okay. Without objection, we unanimously grant. Mr. Holden?
I don't object, but I think it is important to note that we can be purists on a lot of issues, and I think it would be helpful to your cause, and I believe you believe in it, to work with the chair. I think that we all find ourselves in a position where you are, and hopefully we will work to try to adjust and address concerns to make sure you have success. And as you move forward in reconsideration, I would encourage you to work with the chair to try to find an acceptable place to move your bill along.
Thank you.
Okay.
All right. We will not take that as an objection to unanimous consent for reconsideration, and reconsideration is granted.
Thank you.